Welcome back, everyone, to another episode of the Canadian Immigration Podcast. This is episode 143, entitled The Dangers of Crowdsourcing Immigration Information. And I am fortunately not alone. I have back with me again for the fourth time, Robert Leong, an immigration lawyer in British Columbia. How are you doing, Robert?
I'm good, Mark, and thanks so much for having me back again.
Absolutely, my pleasure. And when we say back again, Robert, we were just going back and reminiscing. And I started the podcast, I think back in 2015. Maybe the first one was released 2014. But Robert has joined me. I was looking back in 2016. It's always it seems like there's a connection with some federal court case that he's been successful with. But episode 31. What to do when LMIAs are refused for improper advertising. So that was 2016. Then we did another one on PR card extensions, what to do if you're outside Canada in 2017, which episode 50, that's actually one you can go back to today and it is still evergreen. It's still great content.
Oh, yes.
And then episode 87 in 2021, credential recognition and other challenges faced by newcomers, which was a very interesting topic. But those were three excellent episodes. And so I was just telling Robert today that he is the most frequent guest that I've had, aside from, of course, Alicia, who's now joined the firm, and we pump out lots of episodes ourselves. But it's absolutely great to have you back again. So how are things? How's your practice? The last time I think you were still working with our dear former colleague, Jeffrey Lowe, in his office, but you've got your own firm that you've kind of established now, and how are things going?
Yeah, it's great. So I've established a firm in 2021, so right about during the pandemic, and so things have really changed a lot in the practice of law, and I'm enjoying it. Certainly having the benefits of being able to work remotely, like so many people are. And it's been great. Yeah. Thanks for asking.
Yes. Yeah, well, there's a reason I have you on. It's because you're one of the immigration lawyers that I most respect in the bar here in Canada. And not only that, you had almost 15 years of prior legal experience before you yourself came to Canada and started your practice here in Canada. So sometimes that other experience just adds to and enhances your ability to provide services in this particular region of the world. So very
Yeah,
neat.
well, thanks so much for saying that, Mark. I mean, I think you're doing wonderfully, some wonderful things in what you're doing. I'm a subscriber to your YouTube channel, so I watch it regularly, and you're doing a lot of new things that am really intrigued by and interested in, and you're doing well. I wish you all success.
Thank you so much. All right, let's dive into this topic. So
Mhm.
none of these topics just pop out of nowhere. Usually I select topics for the podcast that align with what I'm seeing in our practices. And this one in particular came from an email chain that came out through, I think it was SELA, one of our organizations, where someone had expressed concerns about individuals, applicants receiving procedural fairness letters and even refusals on the basis of misrepresentation for failing to
Mhm.
disclose the use of a representative. And in the case of immigration, a representative that they felt was maybe a ghost consultant or an unauthorized representative. And why would this be happening? Well, to a large extent, it comes down to crowdsourcing of information in the context of Canadian immigration. And as we know, Robert, there is no shortage of information, no shortage of websites and groups, Facebook, WhatsApp, where people share ideas and thoughts on how to submit applications versus retaining, counsel like us, immigration lawyers. They usually tend to come and see us when things are going south and, trying to fix it. And so that was the context in which we were trying to sort through this email chain. A lawyer had seen this happen and was wondering,
Yes.
what other people are doing. So the
Yeah.
crowdsourcing on websites is one particular aspect, right?
Yeah, I mean, think about the days before the internet. So you might know somebody who's done an immigration case, and you might say, "Oh, maybe let me have a look at your documents and what you did. Like, how did you frame certain things?" And they may use that as a template to do it on their own, But with the internet, that's kind of grown exponentially, and resources are available to anyone anywhere in the world, and there's a tendency sometimes to rely on them to copy and paste, and that leads to a lot of problems, because then we can face a situation where the officer is looking at multiple applications with very, very similar types of documents, or phraseology being used. Yeah.
Indeed. Yes. And when you look at the proliferation of everything from just basic websites to these groups, like you said, people will, if let's say, for example, and it's always good to start off with an example. So I think of one consult I had earlier this year where I was contacted by two individuals, and I think they were in Ethiopia maybe, who had submitted a
Hmm.
visitor visa application, and they were a part of this group, this online group. I don't know which particular forum they were a part of, but there were over 100 people who had indicated that they had their visitor visas refused. And the reason was for misrepresentation, for failing to disclose the use of a representative. And we know in Canada that individuals who choose to pay someone to help them with their application, that individual that's being paid must be a member of a regulated immigration consultant in Canada, or a Canadian immigration lawyer, or a lawyer within Quebec or any of the provinces. And so that requirement is mandatory, and you have to disclose it. Well, when immigration sees, like you've said, similar fact patterns, similar templates, then they start to think, well, this must be a bunch of people who are using an illegal consultant, or someone that is not authorized, an unauthorized representative, and so they just make the assumption, well, they must be using them, and so we're gonna refuse. And so these individuals had come to me because they'd received the
Hmm.
procedural fairness letter, and this is going to lead to your case too. That we're going to
Hmm.
talk. Robert's got a case a few years back now that was right on point, but these individuals in their crowd, the like crowdsource of information, there were individuals that were saying, here's how you respond to the procedural fairness letter, this is what you
Hmm.
need to do. And so not only were they being caught because in their case there was, I can't remember if it was a website or someone had provided a sample statement of purpose, why you want to come to Canada and why you're applying for your visitor visa, and then everybody had used that template. Even though they were filling in their own basic information, they were still keeping a lot of the words the same. So in addition to the crowdsourcing and an officer just seeing a number of files coming across their desk that all look the same, we now have AI. And so we
Yes.
know that immigration is using that, right, Robert?
Hmm. Yeah. So, yeah, the case that you mentioned, I mean, it basically came out of China back in 2017. And what happened in that case was that a lot of people had to have their documents translated. So it's very common to go to a translation company. So there was this translation company who, apart from translating your documents, also offered other services. So they would help you to organize your documents. They would tab it in the way that was according to the checklist. So number one, they'll put tab number one and so on. They'll organize it for you. They put it all together for you, and then they'll courier it out to the visa office for you. And these were all paid services, but they're not exactly immigration advice or immigration services. But what happened was that, can you imagine, on the visa office side, they receive a whole bunch of applications, all originating from the same address, all tabulated the same way, with the same, stickers on them. And they're saying, hey, there's an immigration consultant you're using, a ghost consultant, which you haven't disclosed. And so they gave everybody a procedural fairness letter. And now what happened was that once all these people got procedural fairness letters, and they didn't have any, legal advice. It was very common in those days for China. You go onto the internet, they have all these discussion forums.
Mhm.
And on these discussion forums, you will often find a very helpful person who would then post on the discussion forum, well, if you get a procedural fairness letter, this may be the way for you to respond to that. And that's exactly what happened. So a lot of these people, they did that and submitted their responses to the procedural fairness letter, and then got refused for misrepresentation, because now they're saying, we told you you've been using a ghost consultant, and then, aha,
Hmm.
all your responses all look the same. That's
Yes.
further confirmation that you've used a ghost consultant. So they all had their applications refused, and that's what led to this case, where it was a leading case in a leading applicant in, I think there was more than 50 judicial review applications that were all heard together, all arising out of the same agent's office in China. Yeah.
Interesting. And so
Yeah.
in the end, tell us what happened with the
Well,
case.
in the end, it was really a technical issue. So, um, because there were allegations of misrepresentation arising out of the responses to the procedural fairness letter, um, the case turned on whether the officer gave an opportunity to respond to this new allegation based on the responses to the procedural fairness letter, and there wasn't any. And so the decisions were actually set aside and was sent back to the visa office. I acted for a couple of clients in that, and they eventually did manage to get their PR approved. Yeah,
And a little bit more money it cost them, and a little bit more pain, a little bit more suffering, and
yeah.
and this is what people are now going to start seeing more and more. And it's interesting, Robert. I just did a uh, uh, another episode with Pentea Jafari, who has been this managed litigation she has with the
Oh
self-employed
yes.
applicants in Iran. And I've done a
Hmm.
couple of episodes with her. And it's interesting. This crowdsourcing of information, the internet, the use of artificial intelligence by immigration, all of these tools and mechanisms are now allowing us to see patterns where they may never have, we never may have seen them before. And so for Pentea, she was able to see, because of, the fact that one, immigration consultant had done a lot of those applications, she was able to identify patterns that normally would never have been caught, in terms of how the government was and the department was choosing to dismiss, and refuse applications, which arguably were unjust. We'll leave it at that. But now, on the side of immigration, with their use of artificial intelligence and how they use it for pattern recognition algorithms, and to basically identify inconsistencies and similarities in applications, it's now creating a situation where people who do use crowdsource information are putting themselves at risk, that IRCC is going to jump to a conclusion that they used an unregulated or unauthorized, representative, without properly disclosing. And it's interesting, as I was talking with my staff about this before we went on the podcast, the reality is many counsel like us, we may have similar ways of doing things, and we may
Hmm.
have similar submission letters and things like that. And there's nothing wrong with having structured an expression of your reasons for coming to Canada as a visitor, and using the same form or structure of a document for multiple clients, like many firms do that. But the difference is, we are authorized representatives. And so if an
Hmm.
officer sees similar patterns, well, they're like, oh, okay, it's wholly immigration law. This is kind of the way they structure their submission letters, but they know we're paid representatives. The problem exists when people are using crowdsourced information, and they're giving immigration the impression that they may have used someone to help them, that and paid them, where they're not authorized to provide immigration services. So this is kind of what we're faced with, and people are now. It's one thing to get a refusal, but it's another to get a refusal based on misrepresentation. And why is that, Robert? Why is a misrepresentation refusal so much worse than just a refusal or an incomplete application getting returned.
Yeah, well, um, if you're found to have misrepresented in your application, that leads to a finding of inadmissibility. And an inadmissibility finding based on misrepresentation is a ban of 5 years. So that's a long time. It's not good well, I wouldn't say good, but, having a refusal in itself is already bad enough, right? But to have a ban for 5 years, and that 5 years stays on your record. So if you're applying for a visa to the US or to Australia, for example, and they're asking you, have you ever been refused or found inadmissible to any other country? You have to say yes for misrepresentation, and that might impact, your ability to get a visa to some of these other countries as well.
Yeah. And many people don't
Yeah.
even think about that, Robert. Obviously, misrep is huge because it's not like you can just reapply. This is a 5-year bar. And in all honesty, if you're applying for a visitor visa and you've received a 5-year bar for misrepresentation, it's going to affect you a whole lot more than just that 5 years that you have the inability to apply. It's going to color your application and your immigration
Oh,
history in Canada and those other
definitely.
countries for life. And
Yes. So
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 the consequences.
even after your 5 years, sorry, even after your 5 years, so you may say my 5-year ban is up, I can now apply, but that stays on your record. So when you put in a new application and the officer sees, well, this person had been found inadmissible for misrepresentation, so I may want to, spend a bit more time to scrutinize the new application. So there are a lot of, consequences to that.
Yeah. Yeah.
Yeah.
Tons. Let's talk. I want to talk a little bit more just about what is happening on the immigration side of things. So we know right now that there are just massive numbers of people that are vying for a small number of permanent resident spots and that are here in Canada that are looking for pathways. Alicia and I, in the previous episode 141, talked about what's happening in the world of PNPs, how they're ultra competitive, and people are always looking for an edge. And when it comes to people that are applying, immigration, they do not care about you guys, and you need to understand this. Their job is not to make you feel better, to give you second chances. Their job, especially the officers, is to get through these backlogs and these queues as quickly as possible. And if they spot one thing that they see offside, they are more than happy to refuse applications. And when you're applying through, the immigration, any of these immigration programs, despite what the department or the government website makes it appear, these are complex applications. And they're complex because every person is a little bit different. And this is why it makes it so easy for IRCC to identify these patterns. Not only, and to be honest, Robert, I don't know exactly how it works. And there are other of our
Mhm.
colleagues that have a better idea of exactly how they use the artificial intelligence to do the pattern recognition in their algorithms and what they're looking for. But one of the biggest concerns that I see is when people are doing it on their own and they do go to websites. Let's take, for example, I'll give you a practical example, reference letters in the context of express entry. Now, I've taught this since the beginning of time in my express entry courses that I offer in my master classes with our clients. But sometimes their employers will tell them, oh, I don't have time to do this. Just put the letter together. So they've got
Mhm.
they've got work experience, let's say in India, they've got work experience in Canada, and both employers say, just put the duties together, I'll review it and I'll sign it. And so the person does. And the reference letter in the formatting, in the font that they use, and everything is pretty much identical, except because they're doing the same job even, except maybe the letterhead is different and the signature is different and the address. And when an officer is looking at that, that's pretty easy to catch. Like you're looking at an individual, you're looking at the reference letters, and you're like, wait a minute, these all look the same. Well,
Mhm.
one of the things they're going to think is this even accurate? Did this person just make this up? Is this fraud? So that's in the olden days, since the beginning of time, long before AI, this was a reality. And so I've advised people I've warned them, do not rely on templates that you find online. You need to make sure that they're customized, that you're doing it, because no two companies, a company in India and a company in Canada, is not just going to use the exact same format on a reference letter. And I use that as a very, very easy example. But in the
Hmm.
examples that you've talked about, the way a package is put together, the example I gave with the visitors I can't remember, like I said, if it was Ethiopia or Africa or where it was, where they're all using the same kind of template, or a study permit application where, and we talked about this before, where someone then takes Chat GPT and says, hey, I'm applying to study in Canada. Here's a few facts about me, generate a statement of purpose for me, a study plan.
Hmm. A
And
study plan.
voila, it's generated, right? And I know you had some thoughts on that, and you had attended a session where it does a
Yeah.
good job, like from the the standpoint of what Chat
Yes.
GPT can generate, like it's not bad considering if you're an individual who knows
Yeah.
nothing about immigration, but there are dangers to that.
Yeah, I mean, I watched a live webinar of a demonstration of using ChatGPT to generate a study plan, and I tell you, it does a fantastic job, you know. But the danger here is now we're not saying that you shouldn't uh, go through the internet to look at resources to help you, but the important thing, and you mentioned it before, is to customize it, to personalize it to your case. Now, there is no one person with the same facts and background as the next person. So if you personalize it, there's no way that it will be identical to someone else's. And that's important. I mean, that there's actually a Supreme Court case called Hillowitz. It's about medical inadmissibility.
Mm-hmm.
And one of the principles from that case is that, immigration was saying if you have a certain medical condition, you're inadmissible because of this, that, and the other. And that case said that, it's not good enough to say that you're diagnosed with this condition. You have to personalize the assessment. How does this condition affect this particular person? So, in the same way, when you're preparing your application, sure, you can rely on resources, you can look at them, you can refer to them, but you have to personalize it to your case and make sure that it's accurate for your situation and not copy and paste. That's a very lazy way of getting yourself into trouble. Yeah.
Yeah. I'm glad you brought that up, because that was exactly what I was going to say. When it comes to Canadian immigration, you can't be lazy. You can't afford to be lazy. And
Mhm.
so, yes, obviously you want to use all of the amazing resources that are out there, but you have to be careful too. Back to the Chat GPT discussion, I've always wondered, okay, if someone is coming into Canada and wants to study, and they're going to a specific school, a specific program, and they're coming from a specific country, and the facts kind of align. Well, what I haven't tested is how close the study plan would look if you entered in virtually the same fact scenario and twice. Would it generate a study plan that's virtually identical? I just don't know. And so no matter what source you're using, even if you're using a representative, you need to make sure that you know exactly what's going in there, that your unique situation is being portrayed accurately. Because I'll be honest, Robert, there's some representatives out there that do a large volume of applications, and
Mhm.
even in the world of business immigration, there were times where I was doing 30 or 40 applications for a particular client, and it wasn't really a concern if the basic foundational information for an intercompany transfer was the same and you're swapping out names. That's okay. But in the context of an individualized assessment, when you're applying, and if there are similarities, what I do know is that the government systems now have the ability to scrub and assess and to find those patterns. And if you're in a situation where they start to see patterns because 50 people have used Chat GPT and all of the responses are very similar, you could unwittingly expose yourself. And yes, there are mechanisms to deal with it if the allegations are unfounded and you didn't do those things. And maybe, Robert, we can just touch on those very, very briefly in just a little bit here, what to do if you do get a procedural fairness letter. But I just want to reiterate that it's really important that you take ownership over your own applications, that you know what's going in, that you are working collaboratively with your representative, because they can only do what you use and create an application based on the information that you share with them. And if they're not asking questions and they're saying, "Oh yeah, I'll help you file your application," and they're not asking for detailed information, then be warned that they're using some template and they're just plugging your name and basic tombstone information in, and you could be in for a whole host of problems. We won't even talk about, the importance of not using unauthorized representatives. Obviously, if you're going to choose to pay someone, they better be a regulated immigration consultant or an immigration lawyer in Canada. So, Robert, if someone is, and this happens because they're booking consults with us, if someone gets a procedural fairness letter in these circumstances and they reach out, and Robert's contact information will be in the show notes for the podcast as well. But if they contact you, Robert, and say, "Oh, I just received this procedural fairness letter. They're alleging misrepresentation for using an unauthorized rep, and I did it myself." How do you respond to that person?
Well, as with most inquirers, we often say that, look, we have to obviously look at everything that you've done. How did you manage to draft that? What did you rely on? And find out what the specific allegations are to see whether there's any truth in there, whether they may have been a misunderstanding by the officer, and so on. Um, here's where there's, you know, just to say that even in legal practice, there are some challenges, right? Because we often have clients come and say, well, I just need you to do this for me. Tell me how much it is. And oftentimes I have to tell them that, well, I can't really tell you how much it is until I do a full assessment of what's the situation, because I have to individualize your case. I have to look at what's the problem that is peculiar to your case. And the challenge that we have as a legal practice is that from the business point of view, it's very difficult to scale things. It's
Mm-hmm.
very difficult to have a cookie cutter kind of approach with legal practice. So I think the danger is if you approach somebody who can give you a cookie cutter approach, then you have to be very wary. You have to make it personalized. Yeah.
Yeah. And that's one thing I've said to my staff over the years. It's quite frustrating. All of my real estate lawyer friends and my business law friends, they've got all these templates and precedents and, this whole database that they can systematize. But in our world, we wouldn't dare to look at an application that we did for someone even yesterday and use it as a template that we copy straight up when we're filing one today. The government is
Yes.
constantly changing things. They're modifying instructions, forms are getting updated, processes, even the documents that we include, sometimes the requirements change. And so it makes for a horribly inefficient practice, but one that, it really forces you and I to become really good you know at creating stories, at putting things
Yeah.
together, really advocating on behalf of our clients, which in all honesty, it's something that I really love. I really, really enjoy it. So if
It
someone
actually
comes, oh yeah, go ahead, Robert. Yeah.
No, I was saying it actually brings us full circle to what we were talking about, these online forums. Because, I mean, as an immigrant myself, I'm on Facebook, I'm on some groups for new immigrants and so on. And now and then you get somebody posting, oh, I'm thinking of applying through Express Entry. Can somebody who's done it before share
Yeah.
with me
Yeah.
how they did it? And it was very interesting. The other day I saw somebody said, yes, I did it more than 15 years ago, so you can speak to me.
Yeah.
And I was scratching my head and I was thinking, Express Entry didn't come into play
Yeah.
15 years ago.
Yeah.
But there are all these very helpful individuals who are prepared to
Yeah.
say things on forums, and you really just got to be careful who you're talking to. 15 years ago is not the same as now. I mean,
Yeah.
look at all the different changes and policies that are in place now as compared to 15 years ago.
Yeah.
So, it just brings us full circle to that discussion. You got to be careful. Yeah.
Yeah. It's a whole different world. I'll give a practical example. People like examples of this, of the dangers of this. So I had some individuals book a consult with me, and they had received a procedural fairness letter, and it
Mhm.
was for misrepresentation. And the problem was they'd questioned whether or not the spouse, the husband, in this case, he was the accompanying spouse, truly had no work history. Because what had happened was they had some friends, same country, went through the process themselves, got their applications approved, and then helped them with theirs. And they knew that you only needed to list in the work history section the work that you wanted to claim points for. Accompanying spouses, there's no points for foreign work experience, so so you don't need to include it in the work history section. And I personally have a practice of saying no for spouses. Do you have work history that you want to claim if they don't have any Canadian? I just know there's no point in adding anything in there. But somehow these helpful friends of theirs also made the decision that, well, if you put no in that work history section, then you should also just list unemployed in the personal history section. That was the advice that they'd given. So obviously their friends had gone through, and officers aren't perfect. They miss things, and they'd gone through, gotten approved, and then told their friends to do the same thing, which of course is misrepresentation. In the personal
Mhm.
history section, you have to list very clearly everything that you've done in the past 10 years. And so in that case, what I see, this is an example of situations where people have gone through, submitted their own applications, and they did something actually wrong that the vast majority of time would be rejected. But an officer overlooks it, misses it. They're racing to get these processed, and they just approve it when maybe 9 other officers would have refused it. Then that person who got it approved goes back to their forum or their group and says, yeah, this is how you do it. Mine was successful. And everyone says, well, if yours was successful, then I'm going to do it. And then lo and behold, there's a whole bunch of refusals. And when they go back to the group and tell Freddie, who offered that helpful advice, he's nowhere to be found. And
Yeah.
so
Yeah.
there's some real challenges with it. So I guess, Robert, one thing I'd ask you is, we've talked kind of briefly about the dangers of relying on crowdsourced information, but lots of people will ask me, well, should I hire an immigration lawyer? Like, what's the difference? The government says I don't need to hire anyone, and it costs money. What would your response be to this? Because I face it all the time, and the last thing we want is for people to say, "Oh, those money grubbing immigration lawyers, why would I pay them, thousands of dollars or whatever to help me with my permanent residence when everything is free
Yeah.
online?" And what's your response to that question that we get all the time?
Yeah. I get that question all the time as well. And I mean, to a family, to a person, usually a decision to immigrate is a very important decision, right? I mean, it's almost as important as getting married, right? You're entering into a long-term relationship, and it just amazes me that people would think to save a few bucks on such an important decision. And yes, I understand that it can be costly to use immigration lawyers, but with decisions that are of so great of importance, do you really want to be relying on some anonymous person on the internet giving you advice on how to do it? You wouldn't uh, try to operate yourself instead of going to a surgeon just by looking at how to do it on the internet. And I often give this story, and we talked a little bit about this. The
Mhm.
story about this technician, right? So this business had this machinery that was very important, was running, and then it malfunctioned, and they had to bring in this technician. Technician went about looking at it and decided, okay, he took out a screw and then tightened something, and then the machine ran beautifully, and the business was saved. And he charged the business $10,000 for that service, and the business was, uh, you know, just surprised, like, can you please itemize your bill? Like, how did you charge 10,000 for that? And so this technician itemized the bill, saying $1 for the screw, $9,999 for knowing where the screw goes to fix your
Mhm.
problem.
Yeah.
So it may look as if it's a simple thing, but you need somebody with the training, with the experience to be able to know what to do in a certain situation. And that's the value that you're paying for,
Yeah.
not the screw, right? So
Yeah. Absolutely.
sometimes I tell that story.
Yeah. No, it's a great story. It really does illustrate, the advantages of hiring an immigration lawyer. And I know you and I, we've been at this game for a long time, and over that time you do learn things. Right? Not only,
Yeah.
obviously, the law is like the very base level, knowing what the law is, what the requirements are, but the vast number of years experiencing, the whole process with a variety of clients and a number of different circumstances, and understanding kind of how government thinks. And I had the privilege of working as an officer on the border, and with the hearings officers while I was going through law school. So that gave me a little bit of an understanding of what goes through their minds when they're processing these applications. But you're absolutely right. Like, how do you quantify that? The value of
Hmm.
that, versus, yeah, versus just some helpful information online that points you to the right place on the government website. I love those. I have no problems with people who say, hey, here's the link to the government website where you can get the basic instructions. But even those basic instructions, sometimes there are so many gaps. And how do I know that? Because, yesterday, I think I had 6 consults yesterday with people, all with questions about gaps that they just weren't sure where to, get the answer to. So when you have individuals, Robert, obviously, that the book consults that come to you that have received a procedural fairness letter, practically speaking, or maybe we could even take it one step further, have got a refusal on their application because they didn't appreciate what they were asking in the procedural fairness letter and didn't respond properly, and now have a refusal in their hand for misrepresentation. What options do they have available at that stage? Could you just talk us through that just briefly, and then we'll wrap up the podcast.
Sure. I mean, to understand how decisions are made, first of all, um, the law has established that before you make a refusal, before the immigration officer makes a refusal, they typically have to provide a procedural fairness letter to the applicant to give them an opportunity to respond. So once you're in receipt of a procedural fairness letter, that's an indicator already that there might be a refusal looming. So it's very important to immediately hire somebody who knows what they're doing to be able to respond to that. Now we've had some success in explaining things away, so that's fine. But there have also obviously been a lot of cases where no matter what you say, you still end up with a refusal because that's like a precursor to procedural fairness letter. So if you end up with a refusal, so again, you have to get a professional help immediately because there may be options for appeal, there may be options for judicial review if you don't have a right of appeal, and there are certain limitation periods to those rights, whether to appeal or to file a judicial review. And once you pass those limitation period, it's very difficult to get an extension of time. So those would be situations that you know I'm a very DIY person myself, so I try to do some of the plumbing in my home, the electrical stuff, simple things. But I reach a point where I have to tell my wife, this is beyond me.
Mm-hmm.
Like, I know I can't do this because I'm not trained, and I don't want to blow up my house. I don't want to get electrocuted, and I'd rather pay somebody to do it. And you have to come to that realization that, if it's something that involves refusals or procedural fairness letters, you don't really want to try and do that on your own.
Yeah. And that
Mm.
actually, I can't help but end with one last little anecdotal story. And this is a personal one along the exact same line that you had there when it comes to professionals. So, I fancy myself as well, kind of a DIYer when it comes to stuff at home. And in the cold winters here in Lethbridge, Alberta, um, if you do not blow out your underground sprinklers, your irrigation lines, they will freeze and crack and break. And so I'm not going to, admit fully to the fact I delayed and probably didn't do it like I should have. But come spring, I turned on the sprinklers, no water is coming out, and I noticed that the grass was a little damp in a certain spot, which was absolutely We had not blown them out, and the pipe cracked. And so I told my wife, I said, okay, I'll fix it. It's not a big deal. I'll just dig it up and it's fine. And day passed after day passed. I turned off the water to the outside of the house so that, the line wouldn't keep leaking. And then my wife and I'd meant to get it done before we went away on a trip, but I just didn't get it done. And the kids were at home. And we have a hot tub outside, and the hot tub runs off of the same line. And they decided that they were going to dump the water out. They were going to refresh it, and so they turned the line on to the outside, which then caused the water to basically pressurize those irrigation lines and just drain. And so for almost 2.5 days, Robert, the water was draining to the point where my kids didn't realize it, but my neighbor called the city and said, there must be a line break because we're getting water in our backyard. And so, yes. So needless to say, the city knocked on the door, and the kids didn't understand at first what was going on, led them around to my irrigation box, and he turned the water off. But I think that month my water bill was $1,000. But the reality was, if I had just hired a professional to come and do it, they would have done it in about 20 minutes and it would have been done. And even when I came back, the extra cost when I didn't do it right the first time, oh my goodness. And I saw so many parallels between people who always come to me after they've tried to do it first themselves, whether you think it's easy or not, whether you think you have time or not. Time is just as important as knowing what to do. And sure, if in some cases, if you're submitting a spousal sponsorship, well, if your spouse is here, they're on a visitor status, you submit your application, it gets returned as being incomplete. Well, you still got a second shot at that. But when it comes to express entry, getting things wrong or returned for being incomplete can literally remove the ability of someone to ever becoming a permanent resident. And we know with express entry in those very competitive applications, it's not a case of just going back into the pool. Sometimes people have birthdays, they lose points, their work permits are expiring, they're going to fall out of status. And so there are so many landmines all over the place. And as an immigration lawyer, and I know you feel the same way, we would by far rather have you reach out to us just in advance when you're getting started. We can help you to make sure that you're on the right track. Whether you choose to retain us or not, we can at least make sure you're on the right track, you know where to go. And then we're here to, for as much or as little support as you need. But what I tell people, I sell peace of mind. I sell a good night's sleep. And that's one of the most important aspects of retaining our firm. But everybody has to, they have to make decisions that they feel comfortable with. And the most important part of this podcast was just alerting people to the dangers of using crowdsourced information, because never before has it been as much of a factor as it is now. And with immigration, their mentality of just refusing and culling people out as quickly as possible, there's no more effective way than to group a whole bunch, 200 people, and say, you all use the same unauthorized representative, and so we're refusing you and we're barring you from applying in the future, and boom, it's done. So remember, reach out to Robert or me at the beginning, Robert and I, but if not, the moment you get that procedural fairness letter, that is the time when you absolutely should contact us. And worst case scenario, if you already have a refusal, same story. Do not delay because of the limitation. And Robert, just for their purposes, what are the limitation periods in terms of filing leave applications, depending on if you're inside or outside Canada?
Yeah, for a matter arising in Canada, it's 15 days. So that's a very, very short window. For matters arising outside of Canada is 60 days. But, time passes very quickly. I mean, 15 days, you really got to get going the moment you have that refusal.
Yep. So do not delay. Well, thank you so much, Robert, for joining me on this episode of the Canadian Immigration Podcast. I want to give a shout out to the Canadian Immigration Institute, and in particular, the 2024 all newly created Express Entry Accelerator DIY course, which is the sponsor of this podcast. There are links in the description where you can access that. There's contact information for both Robert and myself in the description. And if you're listening to this podcast, make sure you subscribe on iTunes or Spotify. If you're watching it on YouTube, subscribe to the channel so you can catch the next episode and all the other content that is released. So, Robert, thanks so much for connecting in. Really appreciate it. And I guess one constant within immigration is change. So we'll see what's coming in the future for us.
Thank you for having me. Great to be on.
You bet. Take care.
Okay.